Welcome back, my fellow patriots, to the Save Our Republic daily video broadcast. Today we are talking about methods of constitutional interpretation. We're one amendment away from the end of the Constitution, but I thought I'd jump into this just before we finish so that we have some understanding of what the importance of constitutional interpretation really is. So we understand there's a Constitution. I've gone through at least at a very high level, many of its provisions. But the question is what does it really mean when the rubber hits the road, brass tacks, who makes the decision and how? So we talked about Article 3 of the federal Constitution, which establishes the federal judiciary. In 1803, in the pivotal case of Marbury versus Madison, a monumental case, the court found that its duty was to interpret the law and that it had the authority and duty to strike down unconstitutional laws or executive actions from the Congress, the president, the state legislatures, or governors. And this was not particularly clear in the Constitution. Many people thought it was a natural consequence of giving the judicial power to the Supreme Court and to Article 3, but it wasn't expressly provided. So what's happened over the years is a debate over what is the right method for the Supreme Court justices to interpret the Constitution. The original prevailing perspective is ironically called original intent or originalism, and that idea is that the Constitution should mean what it meant at the time it was adopted. It shouldn't change over time, and that it has a fixed meaning. And there's a debate about if it's the framers that wrote it, what they meant, or those that voted for it and ratified it, what they meant. Usually they sync, but not always. And so, but the idea is that there is a limited amount of range in connection with constitutional provisions. And I'll give an example. No one in 1791 or 1800 or 1795 would have thought that nude dancing was protected by the First Amendment. They would have laughed at that, scoffed at that idea. But there are others in modern days that say, we have gained great insights. The Constitution should not be fixed in time or in meaning by what the founding generation thought, or as amendments are adopted, those that drafted and ratified the amendments over the course of time. But we know better, and we should take into light new circumstances and the evolution of our thinking and of society at large. And perhaps because nude dancing could be argued to be an expression of one's political ideology, culture, whatever it might be, and because it may be necessary for some people to fully actualize and live out their life, that we need to protect nude dancing as part of the First Amendment. I use that as an example because it's so clear that no one back in when the Bill of Rights was adopted would have ever thought that nude dancing was protected. And yet there clearly are scholars and some others that think that nude dancing should be protected by the First Amendment. There's a whole slew of cases where these issues clash, where the original idea of the Constitution is pitted against new interpretations, novel or evolutionary changes. And so those that adopt the more flexible approach might call themselves believers of the spirit of the Constitution, a living Constitution. Who wants to support a dead Constitution? So there's some other issues and perspectives in connection with interpreting the Constitution. For example, you can look at the structure of the Constitution. You can look at the practical realities of decisions. You can look at kind of traditions and look at what prior courts have ruled. All these come into play, and often they all come into play in a particular case, or many of them do. So it's important to know what perspective Supreme Court justices have in connection with their jurisprudence to gain an understanding of where they might be headed in connection with decisions. Of course, it's unethical for a judge to say, I will rule a particular way in a particular decision. Otherwise, they should be disqualified because they're not going to be fair and impartial. But generally, you get some sense for where they're headed in connection with the general overall philosophical jurisprudential perspective. And we'll have more to talk about that as this series continues. Until next time, don't forget about America's Survival Guide at americasurvivalguide.com, Patriot Week at patriotweek.org, and the Patriot Lessons American History and Civics podcast. I forgot to mention what the title is, which is it a living constitution? We talked about that. Is it a dead constitution? We talked about that, fixed in time. And then there's this idea of a zombie. And the zombie idea is that there is a decision that's made, people rely upon the decision, and even though some justices might think that the decision was originally wrongly decided, they refuse to reverse it because of reliance by society at large in connection with the decision. And so even a wrongly decided case may perpetuate on as kind of a zombie. Again, until next time, God bless you and God bless America.